So while it is our responsibility to challenge the court, to scrutinize the court, to put the nominee to a test, it is also our obligation to honor elections, respect elections, and to protect the court. I view my role as a United States Senator in part protecting the independence of the judiciary and making sure that hard-fought elections have meaning in terms of their results within our Constitution. And the election that I am worried about has passed. The election that all of us are concerned about is our own coming up. How do you balance those two? How do you stay within keeping your job and honoring the fact that the people have spoken? This is what Senator Graham, Phil Graham, said about Justice Breyer. So I'm going to vote for this nominee, not because I agree with him philosophically, but because I believe he is qualified. I believe he is credible. I believe his views, though they're different from mine, are within the mainstream of thinking of his political party. Whether I like it or not, and I do not, the American people put Bill Clinton into the White House. This nomination is a result of that. I'm not going to stand in the way of it because I differ philosophically with this nominee. I'm going to vote for her, and that doesn't mean I'm pro-choice. I'm very pro-life. I'm going to vote for her because I believe the last election had consequences, and this president chose someone who is qualified, who has the experience and knowledge to serve on this court, who's in the mainstream of liberal philosophy and understands the difference between being a liberal judge and a politician. At the end of the day, after the hearing, it was not a hard decision for me to make. I thought she did a very good job, and she will serve this nation honorably, and it would not have been someone I would have chosen. But the person who did choose, President Obama, I think chose wisely.
In recent years, the progressive wing of the Supreme Court has authored opinions that would have denied Americans their right to keep and bear arms and severely diminished the right to free speech during election time. These same progressive justices succeeded only a short time ago in ruling that a citizen's property could be seized by the state for private commercial development. These justices are ignoring the text of our Constitution, the plain rights guaranteed by our Constitution, in order to advance what they think are better ideas, their vision, their political agendas, frankly. This progressive, activist judicial philosophy strikes at the heart of our democracy and is a direct threat to our liberty. Judges are lifetime appointed. They're not accountable to the people. President Obama himself has said that judges must shed their neutral constitutional role and impose upon the nation, quote, their broader vision of what America should be. And that's how he said he would pick judges. And this is certainly the kind of judge President Obama believes he has found in Ms. Kagan, someone who shares his progressive, elitist vision and is willing to advance it from the bench. Indeed, throughout Ms. Kagan's career, she has been more deeply involved in politics than law and has frequently put her politics above law. She's never been a judge, never argued even a case before a jury. She has practiced law for just 3 years. She has less real legal experience than any nominee in the last half-century. The experience Ms. Kagan does have, however, is mostly that of a political lawyer and a policy advocate. And whenever her political views have clashed with her legal obligations, her vision of what America should be and not her duty have too often won the day. As a Supreme Court clerk, she pursued a progressive agenda without regard for the Constitution's text or history. She even wrote she was not sympathetic to an American's constitutional right to keep and bear arms. And as a top aide to the President Clinton, she was closely involved in efforts to restrict private gun ownership, including a plan to block firearm importations into our country that one Clinton official admitted was, quote, taking the law and bending it as far as we can, close quote. She also worked aggressively to ensure the wide availability of partial birth abortions. Instead of providing President Clinton with sound legal advice based on the best medical evidence, she pushed the President away from his moderate position, his willingness to reach a compromise on this issue. She even helped revise a medical statement to imply a medical need for the gruesome partial birth abortion procedure that really did not exist, when the expert panel had indeed said it never was an appropriate procedure. Next, as Dean of Harvard Law, Ms. Kagan would once again sacrifice legal principle for political gain or advancement of an agenda she believed in. Ms. Kagan inherited a policy of equal and unfettered access for military recruiters on campus. That was the policy. But she reversed this policy, kicking the military out of the campus recruitment office as our troops at that very time were risking their lives overseas. She did this in clear, knowing violation of the federal law, the Solomon Amendment. Some have said that senators are opposing this nomination for partisan reasons, that our qualifications are not in question. But what qualification is more essential for the Supreme Court than impartial fidelity to law? This is not an ideological litmus test, but a core bipartisan standard to which any nominee of any party ought to be held. Senators can and will disagree on the question of how much deference a president is due in his nominations, but surely that deference cannot extend so far as to include a nominee who is unable to serve under the Constitution, as they take an oath to do. The American people will not easily forgive this Senate if we confirm Ms. Kagan to the Supreme Court. They will not forgive the Senate if we further expose our Constitution to revision and rewrite by judicial fiat to advance what President Obama says is a broader vision of what America should be. That's a congressional role, not the judicial role, to figure out what the vision and the policies of this country should be. Now more than ever, we need this court to be an impartial defender of our constitutional liberties. As Vice President Biden's own chief of staff and close friend of Ms. Kagan emphatically said, quote, Ms. Kagan is clearly a legal progressive. In fact, at the hearing, Ms. Kagan was unable to identify any limits on government's power to control America's economic decisions. What Ms. Kagan perhaps failed to realize is that the people should control their government. The people should control their government, not the other way around. That's why no Supreme Court justice should simply rubber stamp any political agenda of a president or Congress, nor should any senator. Our liberties are far more precious than any partisan allegiance. After the Constitution was drafted, Benjamin Franklin was asked what kind of government had been created. Franklin replied, a republic, if you can keep it. Again, the choice is ours. Either we embrace our great, magnificent constitutional heritage that I love so much, or let it slip away to judges who believe that they can allow their own personal core beliefs and philosophies to help them decide how a case should go. Either we move forward more secure in our freedom, or we fall back to the old bankrupt idea of big government, an idea that has failed in every place and every time it's been tried. So let's take a step today in the right direction. Let's listen to the American people, and let's strengthen our commitment to constitutional values. It's that commitment that impels me to vote against this nomination, and why I urge my colleagues in both parties to do the same.